Welcome and thank you for standing by. All participants are in a listen-only mode until the question and answer session of today's conference call. At that time, please press star 1 to ask a question over the phone. Today's conference call is being recorded. If you have any objections, you may disconnect at this time. And now I will turn the meeting over to Ms. Laura Idle. Thank you. You may begin.
Great. Thanks, Jenny. Welcome to the third in our 2014 webinar series on the Support Anti-Terrorism by Fostering Effective Technologies Act of 2002. We'd like to thank all of you for joining us today and throughout the year. Today we'll spend some time recapping what we have discussed in various webinars and answer some frequently asked questions about the Safety Act, the application process, and the types of information that you are asked to submit. If you're having trouble with the audio on your computer, you can always dial 888-456-0327 and use participant code 7562044. The dial-in information is on the left-hand side of the screen for reference. The slides from this webinar are available from download from the meeting session in the upper left-hand corner. It is in a file called Safety Act Webinar FAQs.pdf. The audio for this webinar will be available for download at www.safetyact.gov in the future. If you are new to the Safety Act process, our previous webinars, slides, and audio can be viewed on www.safetyact.gov. Finally, if you have specific suggestions for future webinars, please let us know by sending an email to safetyacthelpdesk@dhs.gov or let us know in the chat room at the end of this webinar. I'd now like to turn it over to Bruce Davidson, the Director of the Office of Safety Act Implementation.
Hey, thanks a lot, Laura. Over the last 18 months, we have discussed a range of Safety Act topics. Safety Act 101, the application process, the renewal process, DT&E designations, and specialized types of applications. Today's webinar, we're going to go back to some of the basics and recap all that we have discussed over the last year and a half. We're also going to focus on the questions that people pose to us in teleconferences, meetings, and in help desk tickets. We'll also be addressing any pre-submitted questions and opening up the phone line at the end. The webinar will consider a range of topics and hopefully provide you with some clear answers to some common questions. OSCI staff members will be available to address specific questions in the chat room during the webinar. We will also have some time for questions at the end. If you have more questions and need additional help to answer your specific issues, you can always contact OSCI via the Safety Act Help Desk at a later time. Okay, so what is the Safety Act? Okay, we will start with one frequently asked question having to do with what the Safety Act is and what it is not. As part of the Homeland Security Act of 2002, Congress enacted several layers of liability protections for providers of anti-terrorism technologies. That's the central purpose of the Safety Act. The Safety Act provides incentives for the development and deployment of anti-terrorism technologies by creating systems of risk management and litigation management. The reason for the Act is to ensure that the threat of liability does not deter potential manufacturers or sellers of anti-terrorism technologies from developing, commercializing, and deploying technologies that could significantly reduce the risk or mitigate the effects of large-scale terrorist events. The Act creates certain liability limitations for claims arising out of, relating to, or coming from an act of terrorism when QATTs or qualified anti-terrorism technologies have been deployed. For the purpose of the Safety Act, an act of terrorism is an act that the DHS Secretary determines meets the requirements under subparagraph B of Section 444(2) of the Safety Act. As such requirements are further defined and specified by the Secretary of DHS. The Act meets the requirements of subparagraph B if the Act 1 is unlawful, 2 causes harm to a person, property, or entity in the United States, or in the case of a domestic U.S. air carrier or U.S. flag vessel or a vessel based principally in the United States on which U.S. income tax is paid and whose insurance coverage is subject to regulation in the United States, in or outside the United States. And third, uses or attempts to use instrumentalities, weapons, or other methods designed or intended to cause mass destruction, injury, or other loss to citizens or institutions of the United States. So that means that the Safety Act would not apply in the event of a natural disaster. It's not an all hazards coverage. Further, the Safety Act is not a regulatory program, so participation is completely voluntary. But because we're non-regulatory, we also don't publish requirements that you have to meet in specificity. We also are not a test entity, so we do not provide funding or opportunities at our facilities for testing or evaluation of your technology. Okay, so what protections does it offer? So I'd like to touch on a couple of protections offered by the Safety Act. The Safety Act has two primary levels of protections, designation and certification. Developmental testing and evaluation designation is a cutout of the designation category. But let's start with designations in the middle. These are for technologies that have demonstrated effectiveness during operational testing or through prior use. Designation provides a liability cap as well as exclusive action in federal court, no joint and several liability for non-economic damages, and no punitive damages or prejudgment interest. An applicant is required by the Safety Act to obtain liability insurance in the amount of the specified liability cap specified by the Secretary DHS. A full designation and associated certification, which we'll talk about later, normally lasts for 5 years, after which time both can be renewed. Any technology deployed during the period of designation is protected for the lifetime of the deployment. If a technology shows promise but is not sufficiently mature to receive a full designation, a developmental testing and evaluation designation is available to provide protection during further testing or trial deployment in order to collect the additional efficacy data necessary for a full designation. A DT&E designation provides similar liability protections as that provided by a full designation, but with certain limitations and constraints. In general, DT&E designations will provide limitations on the use and deployment of the specific technology, remain terminable at will by DHS should any concerns regarding the safety of the technology come to light, and will have a limited term not to exceed a reasonable period of testing or evaluating the technology, presumptively not longer than 36 months. Further, the Safety Act liability protections associated with DT&E designations will apply only to acts that occur during the period set forth in the particular DT&E designation. In particular circumstances, the department may find that a technology being evaluated for designation may not be mature enough for that level of coverage. In that event, the applicant may be awarded a developmental testing and evaluation designation. However, additional requirements may be associated with the DTED, such as submittal of a formalized test plan and a proposed test location to the Office of Safety Act Implementation. Thus, an applicant may be required to resubmit a formal DT-E&D application. For technologies that have a high level of technical maturity and a history of deployment and use, certification may be appropriate. In addition to the benefits provided under designation, certification allows a seller of an anti-terrorism technology to assert the government contractor defense that immunizes sellers from liability for claims arising from acts of terrorism. Technologies that receive certification will also be placed on an approved products list for Homeland Security. Some of you might also be wondering about block designations and block certifications. The Department of Homeland Security has established a streamlined procedure for providing Safety Act coverage for qualified sellers of certain categories of technologies. These types of certifications or designations are known as block designations or block certifications. Block designations and block certifications may be issued at the Department of Homeland Security's discretion and are intended to recognize technologies that meet the criteria for designation as a qualified anti-terrorism technology, or QATT, or for certification, based on established performance standards or defined technical characteristics. Currently, approved block designations and certifications are posted on the website with details on streamlined instructions, and applicants can file such applications only under the existing active blocks. So please see the active block designation and active block certification list on our website at safetyact.gov. If you are an applicant or a federal partner who has an idea for a block designation or block certification, please contact our office and we'll take your request for action. You also might have noticed our active procurement list, technologies being acquired by specific agencies or participating in government-sponsored programs, who might also be eligible for streamlined processing. So be sure to check that link too. If you're a government contracting officer or program manager and you think you might be acquiring a technology that should be on our active procurement list, please contact our office. Also note, we are planning on having a webinar specific to block designations and block certifications later in this fiscal year in September 2014. Okay, let's move on and take a look at how can I use these Safety Act marks. In addition to substantial liability protections provided by the Safety Act, we also provide Safety Act marks for use in marketing materials. People often ask, how can we use these marks? Do we need to use these marks? The use of the marks is completely voluntary, but if you wish to use them, you must sign a usage agreement prior to receiving the marks. The usage agreement for the designation mark is intended for any materials that your company uses for external publications and materials geared to your clients, customers, or the general public, such as advertising materials, publicly accessible websites discussing your technology, pamphlets and presentations at conventions, seminars and expos, etc. We do require that you use the marks on your external-facing website in connection with any discussion about your qualified anti-terrorism technology. If you have any such website, please be sure that you display those marks if you discuss the technology. However, we do note that this does not mean that companies can use the Department of Homeland Security seal in their advertising materials. Current Department of Homeland Security policy does not permit the use of the DHS seal by private parties without the express written permission of the Secretary of the Department. Okay, let's move on and take a look, see how many technologies have received these Safety Act protections. We're often asked at conferences, how many approvals are there? Well, as of early June, we have 672, starting from the life of the program back in 2003. Because things expire or are replaced with new technologies at any given time, we have generally in the neighborhood of 300 to 400 active technologies with various levels of protection. At the same time, people often ask, what is the percentage of Safety Act applications that are denied? While we do not disclose exact numbers here, the percentage of denials is very, very low. To enhance the chance for success, we encourage companies to start with a pre-application. It does not take much time to fill out and opens a dialogue with our office. Once we get an understanding of your technology, we can help guide you during a teleconference in the types of information necessary for a full application. Our office is available to help you throughout the application process as much as possible and identify potential weaknesses in your application materials that might be addressed early on. Okay, let's shift on and talk about what types of technologies can apply for Safety Act protections. The Safety Act applies to any qualifying product, equipment, service, including support services, device or technology, including information technology, that is designed, developed, modified, or procured for the specific purpose of preventing, detecting, identifying, or deterring acts of terrorism, or limiting the harm such acts might otherwise cause. As you can see from that application, the Safety Act applies to a wide range of products, services, and information technology solutions, provided they have an anti-terrorism capability associated with them. Technologies with Safety Act protections currently span many technology types, including sensors, integrated surveillance systems, venue security at specific locations, software solutions, logistics support and maintenance services, pharmaceuticals, and intellectual property. You can review the technologies on our approved technologies list on our website to get a better understanding of the range of technologies and entities that have Safety Act protections. Okay, a question we often get is, can small businesses apply for Safety Act protections? That is one we're asked actually quite frequently. And the answer is, of course they can. The Safety Act is impartial to the size of the applicant's business size or business situation. Protections have been granted to very small, less than 20 people type businesses, and to very large businesses encompassing several 100,000 people. Some examples can be found on our website. While these businesses range in size, they all have one thing in common. They are the providers of technologies that have an effective anti-terrorism capability. As shown on this slide, during fiscal year 2013, approximately 37% of approvals were for small businesses. So if you're the owner of a small business which produces or otherwise provides an anti-terrorism technology, don't let that dissuade you from considering applying. Okay, now I'm going to pass the baton here to Dr. Idle, who's going to handle some additional questions that are frequently raised.
Great, thanks Bruce. So people often ask, how long will it take to file an application? Well, I think that depends on a couple things. First, there is no prescribed due date or time window for you to apply. Businesses apply when they're ready and when they have all the materials that they think they need to submit. It's kind of like cooking. Even though my recipe for shepherd's pie says 25 minutes to bake, I still have to allow time to refresh myself on the recipe, go to the grocery store for ingredients, find the right size pan, prepare the various layers, assemble it, and put it in the oven. That can be a bit of prep work that isn't accounted for in our timelines. We recommend that first-time applicants and veterans with a new type of technology file a pre-application. A pre-application review includes checking the amount and type of supporting data you have listed against the criteria described in the Safety Act, and noting the strengths and weaknesses of your proposed application. OSAI attempts to complete these reviews in 21 days or less. When the review is completed, you will receive a letter inviting you to take part in a teleconference with the evaluation staff to discuss the merits of your technology for Safety Act protections and to discuss what will be necessary to provide an administratively complete application. After a pre-application, it's up to you to gather the materials you need to complete the application form and submit the application. That can take as much time as you need. We will talk about some helpful hints on the next slide. But once your application is submitted, OSAI will typically review your application and determine if there is enough information to move forward into the evaluation phase within 30 days of receipt. In most instances, you can expect to have a final decision within 120 calendar days if your application is complete upon initial filing. While 120 calendar days is our goal, on average, some applications might take longer. If you have a very complex technology with many components, or your technology is a first-of-a-kind submission, it can take a bit longer for us to complete the review. However, we will be in touch if that is the case. If you feel that 120 days might be too long because you have imminent procurements, you may request an expedited review by filling out item D2 of the designation application form. The decision to grant an expedited review will be made by Mr. Davidson, the Director of OSAI. While we do strive to meet these expedited goals, sometimes they are very ambitious. We also rely on you to submit complete, accurate information at initial filing and respond equally expeditiously to requests for additional information. But what happens if your application is not complete upon filing? Around 30 days after submission, you will know either way. If you do receive a letter stating that your application is administratively incomplete, not to worry. That letter will contain details of the types of additional information needed and/or directions on contacting OSAI for further consultation. There is no timeline for refiling and no penalty for doing so. Finally, we think it's important to point out that there is no fee for filing for Safety Act protections. The only costs you will incur are those overhead costs associated with preparing an application and the cost of your insurance policy that would respond to third-party claims arising out of an act of terrorism. Our next question is for applicants. Well, where do you start? Aside from the length of time involved, prospective applicants often ask me, how do I even get started? I know one of the challenges I have on every project is knowing where to begin. With the Safety Act, if you are brand new, the pre-application is a great, quick way to get started. If you think you have enough familiarity with the application process because of the information on our website, our webinars, or experience, I recommend everyone start with the technology description. If you can clearly identify for what you are seeking Safety Act protections, be it a product or a service that is sold for profit, or something that is provided internally to your business, you can start listing all of the information you might have to support your technology. As you are listing out this information, you should also consider what type of Safety Act application would best fit your situation. Developmental testing and evaluation designations might be appropriate if you have a new product that you are just beginning to pilot or deploy. DT&E designation would give you protections while you collect additional information. Maybe you have some operational deployments already, but not a lot of performance history. A designation-only application might be a good alternative. Or you might just want to file for designation and certification right now. Once you've defined your technology and selected the application type, you should organize your materials, answer all the questions in the application forms, upload your materials, and submit your application. OSAI is able to assist you at any step along the way. Moving on to our next frequently asked question. What is that technology description that you all talk about all the time? It's a good question. As you may have heard us say in previous webinars, and as noted on the previous slide, the most critical aspect of your Safety Act application, no matter the type, is the technology description. But what is a technology description? The technology description is the what and the how of your technology, and it tells us who you are and what you do. It is also sometimes called the Exhibit A. We use the word technology as a term of art. Simply put, it means whatever it is that you provide or use internally that provides an anti-terrorism benefit, be it a sensor, software, a security plan, or whatever you are seeking protections for. We suggest you start by defining your baseline anti-terrorism offering and those elements that are customizable or optional. When describing your technology, try to keep it as simple as possible and do not use marketing language. We are looking for the facts. What is your technology and what are you seeking Safety Act protections for? It is important to be clear and concise in describing your technology. The technology description is what will be evaluated for Safety Act protections and what would eventually form the legal definition of your technology and be protected under the Safety Act. While reviewing your submission, we will ask you for information supporting all aspects of the technology description. For example, if you are providing access control in the security plan, we will want to see information on both. Scoping your technologies matters too. For example, if your company is a security firm providing guards for a commercial facility, we might have a different set of questions if you serve a site that houses special nuclear material. Also, focus on the anti-terrorism aspects of your business. Not everything your company sells or provides is an anti-terrorism technology, and that's okay. Drafting a technology description is intended to be interactive. It is the collaborative process involving you and DHS to determine the most complete definition that can be reasonably evaluated as part of our review process. Also, please remember, if you make changes in the future or update your technology with more components, you might be able to modify those things later via notice of modification. So start with what you are doing today, not what you plan to do in the future, and focus your technology description on the things that you can support. Great. At this point, people typically want me to stop and define a few terms. First, what is a seller for Safety Act purposes? The seller, or sellers, is the corporate entity providing the technology. Please note that the insurance coverage follows the seller. You might also have us refer to the ATT details or the proposed renewal document. These documents will contain your narrative responses to your application questions that don't have web forms. The name is dependent on the type of application you are filing. They must be given this name to upload and should be in PDF or Microsoft Word format. Those questions can be found in the application kit. The application kit is found in our Forms and Info page of the website. The various chapters contain the application instructions and questions for each application type. Finally, again, Exhibit A is another name for a technology description. Next, people like to ask me, what is the best way to organize an application? And really, again, that's always up to you. But we suggest that once you have your technology definition drafted, you really start to work on your Safety Act application. Recall that the Safety Act application process is based on paper submissions, so organization is very important. You have invested time, money, and effort in developing your technology, and you want to show us that time and effort on paper. One way to do that is to assemble a team within your organization to support the application. You should have technical and insurance points of contact, people who know your organization and how your technology was developed and works. Generally, there is no one right person to submit an application. There is a team of right people. Once you have your team assembled, work together to answer all the questions in the application kit clearly and thoroughly. As we have covered in other webinars, the Safety Act application kit consists of questions and instructions. Because the Safety Act covers a wide range of products and services, the questions are designed to capture all technology. OSAI can help you understand how the questions might apply in your particular case. There are no wrong answers to the questions per se. What's important is that you answer all questions and support your technology. As you develop your responses, think about what additional information you need to assemble and to support those answers. Reference them in your responses. As we will discuss later, they can be things like user manuals, training materials, test reports, standard operating procedures, and hiring procedures. You might also provide us with the names of customers or points of contact that can provide additional information. No matter what you provide, tell us a clear story with supporting materials. If you have a lot of supporting materials, make sure that you include a table of contents. We recommend numbering attachments 1, 2, 3, or using letters ABC. Just make sure all your attachments are listed in the table of contents and the file names match the documents you intend to upload. Using section headers, supplying tables of contents, and searchable PDF and Microsoft Word formats for files can help us effectively and efficiently review your materials. We also prefer that you use Times New Roman 12-point black font if you're wondering. Another commonly asked question is, can I submit a draft of my Safety Act application before formally applying? The answer to that question is yes. Typically, drafts are only reviewed after OSAI has had some preliminary communication with an applicant, either through a pre-application or a teleconference. To have OSAI review a draft, you must contact us via the help desk. While we do attempt to review drafts quickly, be advised that sometimes it can take several weeks depending on caseloads. If submitting a draft, we ask that you provide a copy of the answers to your questions and a list of all attachments you intend to supply and support. Do not necessarily submit the attachments themselves unless they are specifically requested by OSAI. Moving on, I've just talked an awful lot about the information that you might need to supply, and you might be thinking your information is business sensitive. I'm concerned about how OSAI is going to protect it. Well, you might be one of those small businesses that we have discussed previously, and your information might be business sensitive. Rest assured that OSAI does have means to protect it. If you're worried about supplying technical, insurance, and economic information, rest assured that OSAI takes information security very seriously. The Safety Act website is DHS-CIO certified and accredited. However, the Safety Act website cannot process classified materials. Please contact the Safety Act Help Desk in advance of submitting your application if you wish to include classified materials. Additionally, anyone that works on a Safety Act application signs an application-specific conflict of interest and non-disclosure agreement. Also, if you have a large amount of information to submit or video clips, please contact the Safety Act Help Desk. We might need you to send in a CD or DVD. We'll make sure that you have that number by the end of our webinar. Our contact information is also available at www.safetyact.gov in the Contacts Us section. So how much information do you need to submit? The types of information needed to support your application vary by application type. For example, we would expect additional information in designation and certification applications versus designation-only applications because of the additional questions. However, we can give you some thumbnail guidance. I call it the define, discuss, and document approach. Whether you're a first-time applicant or a veteran filer, please be sure to fill out the introductory questions, items D1 through D8 of the designation form. Although you may have submitted several Safety Act applications, remember that each application stands alone. Information does not translate from one application to another. Additionally, information such as the registered point of contact for your company may have changed. Completion of each individual item number in the application can provide assurances that no piece of critical information is overlooked. This can make the difference between an application that is complete for evaluation versus one that is incomplete. So, how much information should be included in the application? What is the depth of required information? How much is too much? We advise all applicants to begin with item D9 of the application. This is where you describe your technology together with all elements, components, or services that are included when you make a sale or deployment. D9 is where you lay out your technology description. You can add more details than might end up in the ultimate definition, but details are good. You're describing your technology to experts in your field. They will want to look under the hood, so to speak. You also want to discuss your technology in the responses to various questions that follow. You should provide enough information to support the capability and effectiveness of each product you manufacture or service you provide. You should also provide information that details the manner in which you provide what you sell. This would include manufacturing, procurement processes, and quality assurance processes, as well as all of the personnel policies and procedures. Well-crafted narrative responses to the questions in the application are essential. Simply responding to questions with see the attached policy, or see the attached test results is typically insufficient and may result in an incomplete application. That's because without a narrative description, we have no context for your attachments. Let me give you an example. In response to item D14 of the application kit, you are asked to provide information on technology effectiveness. You provide the response. See attachments 7 through 10, test data. An analyst opens up the series of reports and finds that in one instance, the technology detects a threat 42% of the time, and in the next, it detects a threat 91% of the time. Just looking at those two numbers leads to any number of questions, including what changed to give 42% detection in one instance and 91% of detection in another? Why is there such a large difference? Was the technology the same in both tests? Was the test the same? Any one of these questions could have been avoided with a narrative response such as, in 2004 we tested our product and found a 42% detection rate. Upon review of the data, we found that a number of changes to our software algorithm were needed. We engaged in additional development to fix those areas listed in attachment 11. Tested software fixes internally, see attachment 12, which contains the regression test results from the internal test described in attachment 13, and reconducted the operational test in 2006. In this test, we determined that the technology had a detection rate of 91%. That type of one-paragraph discussion tells us an awful lot about you. First, it takes your two test reports out of isolation and makes them part of your development history. Second, it tells me that you have a procedure to identify the cause of weaknesses, a method to correct those weaknesses, and that you've tested to verify that your fixes worked. That discussion is also supported by documentation. But note how the narrative discussion provides the context for your documents and helps you determine how much information to supply. Use your narrative to help you determine how many documents to provide. Remember that we are available to consult with you on the type and depth of information needed prior to submission of your application. This method also applies to notices of modification. For example, if you're adding a new model, your narrative might go something like this. The Model 5000 adds a series of additional capabilities. See attachment 1 to the already designated and certified Model 1000. In order to add these capabilities, we added the new module and developed software version 12. The new module was tested as a standalone system, see attachment 2, and then attached to the new Model 1000. The new system, called the Model 5000, underwent a full system test, see attachment 3. Note that neither the performance of the new module was degraded, and the new Model 5000 still retains the base capability of the Model 1000, see attachment 4 as test report on the Model 1000 submitted in the initial application for reference. We followed our prior described software development processes, see attachment 5, to test updates to the software, see attachment 6. The new software version was used in the full system test described in attachment 3. Model 5000 is also supported with operator and training manuals, see attachments 7 and 8. Obviously, these are just examples, but as you define your technology and craft your responses, it should become easier to see. And as we noted before, this is a paper review, so please make sure your discussions are as clear as possible. So really, you now really want to know what type of information should be submitted. So as we touched on in the last slide, I want to spend a little bit of time outlining what types of information to submit. In general, what type tends to fall into one of three categories: development, capability, and effectiveness. We'll talk about insurance a bit later. Development is really the story of your technology. Every good application begins with a discussion of how your technology came about. What's your expertise? What's your background? How was your technology developed? Maybe based on your insight and experience, you saw a need that wasn't being met in the private sector. Or maybe you are responding to a specific government request for proposal. How and why will your technology reduce the risk of terrorism? We need to understand if your technology is available for immediate deployment, and that your technology as described has the capability of being an anti-terrorism technology. How do you hire people that can supply the technology? What processes do you use? What procedures? How do you test your idea? Was it based on scientific research and tested in a lab? Or was it developed based on industry or government standards? As you consider capability, start thinking of the materials you can submit to support your story. Those could be copies of policy documents, internal test reports and results, training slides with speaker notes, user manuals, etc. Once we have a good understanding of what you do and how you do it, we want to know how it's working. Effectiveness is simply our way of asking you to show us your success. You might do this through an operational test of a product, or a deployment history with customers who will provide feedback about using your technology to DHS. Please make sure that any customers or sources of information know that DHS will be reaching out to them and ensure that their contact information is current. Please outline what you expect them to be able to address when OSAI contacts them. Other ways to show success include incident reports from things that aren't terrorism related, but might show the effectiveness of your technology. For example, maybe you've installed a chemical sensor that picked up an accidental spill of cleaning supplies. Or maybe your security guards stopped an intruder or responded to a medical emergency. Case studies of success, backed with incident reports and customer testimonials, can demonstrate effectiveness. Sometimes, the normal course of business might give you effectiveness information. Do you do a site acceptance test before delivering a software package or an integrated system? Great. Give us the plan and the customer acceptance documentation. That's evidence of effectiveness. There is no one-size-fits-all data package. So when collecting data relating to the effectiveness, ask yourself, how do I know that what I'm providing works? How do I check with customers to make sure the technology is performing? That second question is about quality control. Do you have quality control processes? Can we have a copy? Do you have the results of quality control inspections? That might include factory acceptance tests for products, or if you provide a service, periodic reviews and updates to the processes and procedures. And last but not least, do you have a plan for identifying problems and making changes? No company or technology is perfect. However, the important thing is, how do you recognize that something might not be working and make a change to get your technology back on track? Finally, while the certification application has a specific question about safety, you might also want to consider discussing safety in a DTED or designation application. Do you manufacture to a specific safety standard? Do you provide training to protect your operators or provide instruction on proper use of your technology? This is all important for us to know. Once we have talked about your story and your successes, we want to know what's next. That's the essence of a certification application. How are you going to expand and ensure that your technology is repeatable across a wide spectrum of deployments? How do you ensure that you have the same high-performing technology everywhere you go? We call that repeatability. If you have the answers to these types of questions, you should be filing an application for designation and certification. If you don't think you can answer the certification questions right now, that's okay. You can always apply for certification later on, after obtaining designation. For products, your answers might address the following questions. How do you know your technology is effective in the long term? How reliable is your technology? How do you maintain your technology? Do you have quality control and after-action correction reports? What is your technology refresh policy? For services, these questions might be, how do you know your technology is effective in the long term? How do you show that you adhere to processes and procedures? What are your quality control and quality assurance plans? Do you retrain employees periodically? How often do you review and update policies? How do you verify that this is done? Do you have POCs that will substantiate your training programs? The basic question is, how repeatable is your technology? How do you know that everywhere you go, your technology will perform at the same high level? Now I think it might be time to define some more terms. The terms we sometimes use might not have universal meanings. And so whenever we're talking about developmental testing, we are talking about tests or events in controlled environments. We would expect that you are documenting those results to make changes before you move into operational tests. Operational tests are tests that subject the technology to conditions which reasonably mimic the terrorist threat that the technology is designed to counter. The key word here is reasonable. We know that not all tests are practical and that operational tests can be expensive. We are looking for a reasonable simulation. As noted above, if you cannot do an operational test, can you augment what testing you have done with incident reports or after-action reviews? Another word we sometimes use is suitability. Simply speaking, it is the ability of a technology to perform and be used in accordance with its performance specifications. Suitability measures might include documentation of quality control plans, reliability data, and indicators of reproducibility between deployments. We are often asked to define what is a representative sample. In general, representative samples of supporting documents should be enough supporting documents of a given type. i.e. training records, personnel records, quality control reports, etc., to demonstrate capability and/or effectiveness for your technology over all deployments. A representative sample should consider and represent earliest dates of sale, all types of services offered, under the technology's varying geographic interests, if that has bearing on your technology, things like jurisdictional requirements affecting training or licensing requirements, vertical markets where different market segments have different hiring, training, and licensing, client requirements. A representative sample of documents should comprise a quantity that reflects the capability and effectiveness of your technology as a whole. For example, if your technology were a security service that operated in 5 states and offered security officers, K-9 teams, and risk assessments, you should consider the following. 3 to 5 records for each year from the earliest date of sale, 3 to 5 records for each state in which you do business, cover all the service offerings, or 3 to 5 in each service offering if your technology is not always deployed with all components. An additional 3 to 5 records for any service offering where client requirements or jurisdictions are substantially different from the other record samples. So for example, if 2 of your states of deployment have limited security officer licensing requirements, you would supply additional records demonstrating that you have an insured baseline of personnel hiring vetting records in those jurisdictions. If your technology has a baseline hiring and vetting procedures, you would caveat those deployments where the jurisdiction requirements are less and highlight that you continue to use your more stringent company hiring and vetting baseline policy. If you have a unique service market, for instance, hospitals or government deployments, you would also include a separate sample of records, 3 to 5 for each deployment, demonstrating that vertical markets' unique requirements outside the baseline are met. Thus, you would provide a representative samples of records for the common baseline deployments and the additional representative samples for any other outlier deployments. The Safety Act is a risk management program, so we do ask for a variety of insurance and financial information. So in addition to the technical data we ask for, you might wonder what financial or insurance information to supply. Because the Safety Act is a risk and liability management tool, we need to understand which of your current insurance policies would satisfy compensable third-party claims arising from, relating to, or resulting from an act of terrorism. For example, is it your general liability policy, your professional liability policy, a product liability policy, an aviation policy, or a standalone terrorism policy? Once you've figured out which policy applies, answer all the application questions relating to insurance. Please note that you have more than one policy that applies. Provide separate answers for each policy. If your policy will expire during the evaluation period, please provide updated information about the renewed policy. For insurance, an insurance certificate is not enough because it never contains premiums, even if it does list out limits. It also fails to provide information on terrorism endorsements. Applicants should instead answer all parts of question D16.1 for each policy separately instead of just providing the insurance certificate. If you don't have terrorism insurance, we will ask you to supply insurance quotes. If you have an insurance policy that just happens to exclude terrorism, the easiest way to do this is to get a quote to add coverage under the Terrorism Risk Insurance Act, TRIA, to that policy. If you have no insurance, can't get a TRIA quote, or just think that the quote is too expensive, you can always get quotes for entirely new policies that would respond to a potential Safety Act claim. We recommend that you get quotes for multiple limits of coverage. 1 million, 5 million, and 10 million is a good place to start if you have no insurance. Remember, for any quote, make sure that you ask your broker and insurance company to assume that the technology will receive Safety Act protections. We also ask all applicants to supply your most recent financial statements, including your income statement, your balance sheet, or statement of cash flows. If the primary named insured for your insurance program is an entity other than your company, such as a parent company, provide the parent company's most recent financial statements, income statement, balance sheet, statement of cash flow, as well. For financials, we need the balance sheet and income statement from the most recent fiscal year and at the same corporate level as the primary insured. Finally, we will also ask you to provide information on reasonable revenue projections. These projections are solely related to the sales of the technology and shouldn't include any revenues that you expect to earn from any other product or service. What if the technology is not revenue producing? That's okay. Just let us know then and provide the technology's cost projections. Whether you're providing revenue or cost data, you should provide a projection figure for your current fiscal year as well as each of the 2 following fiscal years for a total of 3 years of projections. If you receive Safety Act protections, there's one more note on insurance. The first thing you should do when you obtain a Safety Act designation or, as applicable, certification is certify your insurance. Review the section in your designation letter called Liability Insurance Required. This section is typically on page 2 of your designation letter, and the amount is specific to your company. You certify your insurance by logging on to www.safetyact.gov and submit a signed statement on your company's letterhead, confirming that you meet the insurance requirement specified in your designation letter. We have provided an example for you on the slide behind me. Once you have protections, they're only applicable for 5 years, so there's a separate application form for renewal of Safety Act protections. You're eligible for renewal 2 years from your date of expiration, and we strongly suggest that you apply at least 9 months in advance. Preparing for a renewal application begins as soon as you receive your protections. That's because as you're deploying your technology, you are learning lessons from operations in the field and updating your processes and procedures to adapt to an even ever-changing threat environment. The easiest time to document how your technology is performing is while this is happening. That's why we recommend that you start keeping a Safety Act renewal application file right away. You can collect and save information on the performance of your technology during deployments well in advance of your submission for renewal. That file can serve as a repository for updated policies and procedures, success stories about your technology, conformance to new standards, and information from follow-on tests and evaluation. A renewal application can be divided into 4 major topics: performance, specifications, safety, and insurance. In brief, specifications relate to item RE.4 in the renewal application. The intent of this item is to allow our office to gain an understanding of what, if anything, has changed about your technology since its designation or the most recently approved notice of modification. Typically, in addressing this item, you should provide a narrative response to the question and then support your answer with the attachments from your Safety Act file. Items that you should include are updated technical specifications and/or policy and procedure documentation, updated company history and corporate structure information as it relates to the current sellers, updated brochures and manuals relating to your technology, its deployment, and its capabilities, certificates supporting continued compliance to recognized standards, such as industry, national, and government standards identified in your original application, recent versions of quality assurance and quality control plans relating to the manufacturing, deployment, and/or services. Performance is addressed in item RE.5 of the renewal application. The intent of this item is to allow our office to gain an understanding of your technology's deployment over the course of its designation and its performance during such deployment. In responding to this item through a combination of narrative and supporting documents, describe the number and types of deployments of your technology since receiving Safety Act designation. Also provide data relating to your technology's performance during such deployments. Useful information or documentation might include a table with categories of units sold for products, dates of deployment, customer deployment venues and intended use, related contract information if relevant, and points of contact. Test reports containing results from testing completed since designation and certification, which might be internal, operational, and/or field studies. Results from internal or external audits or performance reviews of your technology during the designation lifespan. Data supporting testing against or adherence to updated recognized standards or best practices. Maintenance and reliability data, broken down according to the product if you have multiple product units. If you supply an information technology, we'd want to know about network performance and reliability, for example. You could also provide testimonials and/or contact information for points of contact. If you are providing points of contact, please provide a table of the points of contact, including that person's name, a brief description of how or where they have deployed your technology, and current contact information. Please verify that that hasn't changed in the last 5 years to make sure we have the most recent information. Please also, again, inform them that someone from the Office of Safety Act Implementation will be contacting them. Item RE.6 talks about safety, and the intent of this item is to allow our office to gain an understanding of the safety of your technology when used as intended and of any safety-related incidents that might have occurred during its deployment since receiving designation. In responding to this item, you may describe how you ensure your technology is safe for use as intended. If any safety-related incidents have occurred, you should describe any actions taken in response to such incidents. Supporting attachments might include up-to-date post-deployment safety and hazard reports, recent certificates supporting compliance with recognized safety standards, safety-related manuals, training manuals, or other programs you provide as part of your technology and its deployment. Finally, as discussed a few slides ago, make sure you provide answers to all the insurance and financial information, just as you did in your original application. Finally, last but not least, what about all those pesky technical problems? The answers to some of these and other questions can be found in our FAQ pages on safetyact.gov. You can also reach us via help desk ticket, email, and phone. We do our best to respond within 48 to 72 business hours, but during times of high traffic, it might take a bit longer. We do understand that your inquiries are important, and we'll do our best to respond as quickly as possible. I want to thank you for your attention, and I'm going to turn it back over to Director Davidson.
Okay. Thank you very much for being with us today. It's really important that we get together from time to time and have a talk about where we're headed with this program. Before we take any additional questions from you, we're going to just have a little closing note here about the program. Over the past few years, the Safety Act program has expanded its scope and impact, which has included a number of nationally significant applications. Even though we got off to a slow start this fiscal year due to the government shutdown the first 2 weeks of October, the program has picked up the pace since then, approving 50 applications and 18 modifications so far this fiscal year. We're confident that more good news on approvals will be on the way to many applicants before the fiscal year ends. I should note that the program is having a significant economic impact as well. For applications approved so far this fiscal year, the overall projected annual technology revenue exceeds $3.5 billion and supports almost 34,000 private sector jobs. A wide range of companies have applied for Safety Act protections, from small young companies to larger entities with substantial R&D and technology development capabilities. Our primary goal is to maintain an accessible, customer-focused culture to create a true government-private sector collaboration to enhance the security of our homeland. Although we are a small office with very modest resources, we make every effort to implement a program that operates predictably and effectively and which consistently delivers significant value to those who are perhaps in the best position to understand and act on that value. We thank you for joining us today, for your commitment to advancing the state of our homeland security, and look forward to receiving your applications. Now we'd like to address some questions that we received before we signed on this afternoon with the webinar, and I'll just go through a few of them here. I'll give Dr. Idle the opportunity if she has anything else to add as we go through these. The first question we received is, are hotels qualified for Safety Act certification, and do our vendors, like our fire alarm system, also need to be certified? Best answer I can give you here is that hotels are certainly eligible to apply for designation, certification, or even DT&E under the Safety Act program. Things, if you're a hotel owner or operator, you may want to consider applying for your security management plan or emergency action plan, a technology integration plan, training activities, things along that line. When we talk about fire alarm system, there we'd probably need to know some additional information. Is that a fire alarm system that is above code? Does it have any special anti-terrorism capability? Is it linked in to a larger operational response capability that you have in your facility? The second question we had was, can you share with us any feedback that has been received from stakeholders? Sure, we can share some of it with you. For some of you who are very, very close to this program, you might be aware that there is some legislation pending on Capitol Hill to potentially amend the Safety Act program in terms of its coverage of cybersecurity technologies. As was stated earlier, the Safety Act is limited to providing liability protections for acts of terrorism as determined by the Secretary of DHS. It's very difficult in cybersecurity situations to definitively state whether an act is an act of terrorism, although there is guidance out that we would certainly apply if we were ever faced with that situation. However, I think Congress has understood that perhaps in this area it might be worthwhile to explore amending the Safety Act regarding acts of terrorism when it comes to cybersecurity acts. And there is some legislation on the Hill that is pending. We don't know what's going to happen with that, other to say that that legislation has been introduced in committee in House Homeland and is pending. But associated with that potential legislation, House Homeland has posted a number of letters that have been submitted by the private sector in support of that legislation. And they're from over 20 companies and associations. Some very major associations have come in with letters in support of expanding the program. And while it's clear that the letters are sent in because it makes sense for those associations and companies to have this type of legislation, I also think it's fair to reflect on the fact that those letters probably wouldn't have been submitted if this program is being administered irregularly, inefficiently, or unfairly. So I think that it's pretty clear that the program is viewed by many as one that is being effective, it is meeting real needs out in the private sector, and we certainly hope to keep it that way. So that is one of the major types of inputs we get from our stakeholders, and we thought we'd pass that on to you. The next question is, do only government contractors meet the requirements for Safety Act coverage? And the answer to that is no. In fact, under Safety Act certification, while it does provide the government contractor defense, since it's statutory, all you need is certification to invoke that government contractor defense. You don't have to be a government contractor. You don't have to be selling anything to the government. In fact, most of our technologies are deployed from one private entity to another private entity. True, we do have a good collection of government contracting entities who have Safety Act protections in many instances for their government contracting activities, but it is not a requirement that you be a government contractor to seek Safety Act protections. By and large, the large majority of our applicants who come in are private sector entities who are selling in the broader Homeland Security enterprise marketplace. Okay, next question is, how can a small business with innovative physical security solutions that improve command and control and situational awareness and are a force multiplier bring these solutions to the market only when proven? Only when proven old way companies dominate the contracts for science and technology opportunities. What I get there is if you're a new company or new to the area and you're trying to break into the marketplace and there are a lot of other companies that are there ahead of you, we understand it's hard to do so. We're not, commercialization experts, so to say. We do understand that it is challenging to enter new markets, particularly when there are others that are there beforehand with perhaps substantial positions in that market. But we do, note that Safety Act can provide a way for you to differentiate your technology, perhaps to show some additional risk reduction value of that technology to prospective customers. So some companies have come in and because they're concerned about the risks associated with their offering, and they have received Safety Act protections. Younger companies, and they've done pretty well in the marketplace. So if you have customers who have some risk aversion in the event of acts of terrorism, and you have anti-terrorism technologies or services that you want to bring into the Homeland Security marketplace, we would encourage you to think about the Safety Act program. It is not specifically designed to differentiate products, but it does have that impact in the minds of many buyers who have concerns about risks of deployments themselves. Not only they have concerns about risks of their own activities, such as integrating technologies and providing site security plans, emergency action plans, and other capabilities, but they have concerns about the technologies that they purchase and they procure for deployment. So that is something we just pass along to you. The next question is, how do we renew for Safety Act designation? I think Dr. Idle covered that during our presentation today. We do have a renewal program in place. There are application forms on our website at safetyact.gov. We do encourage companies to think about renewing earlier rather than later. Coming in at the 11th hour and 59th minute generally is not a recommended thing to do. You may not get continuity of coverage if you come in too late with a renewal application. You can come in up to 2 years before the identified termination date on your current designation certification. We encourage you to start looking at that well before you approach the midnight hour on your application coverage. The next question here is what are some liability or insurance liability benefits? Well, here in Safety Act, for designation, the principal protection there is a cap on your liability at a level of liability insurance that the department requires you to carry for third-party claims arising from or related to an act of terrorism. So, for example, if you believe that your operational risk for deployment may be, say, $100 million, and Safety Act were to come in after reviewing your application and cap your liability at $30 million, then you would have the requirement to carry $30 million worth of insurance that would relate to a Safety Act claims and not $100 million, even though you determine that your operational risk may be $100 million. Those are decisions, of course, that you have to make. Just because you have a cap of $30 million doesn't mean that you may not want to buy more than $30 million. Liability insurance can cover various types of threats, particularly if it's commercial and general liability insurance. And you may find that other risks that you have in your deployment space outside of acts of terrorism, might warrant you to cover more. But in any event, under Safety Act, that is one example where you'd get a better feel for how much terrorism-related liability insurance you ought to carry. Okay, next question. We need to know the types of documentation needed for certification for a technology. That sort of depends on what your technology is. It's really specific to whether you're providing a service, whether you're providing sensors, integrated systems. Is it a technology that is an IT-related technology that provides response capability? But during the presentation, I think we tried to indicate that we're looking at things longer term for certification, like reliability, maintainability, availability. How does the technology reflect standards that are widely accepted and in use in the field? And of particular importance, how about your quality control? That is very, very important for longer term health and effectiveness of technologies, for you to have a robust and active quality control program where you are keeping tabs on how your technology is doing, making necessary updates and changes to it, keeping in touch with its operational experience out there, because that's the best way that you know how it is doing, when it is time to make upgrades and changes, and also to develop a good database for yourself so when you come in for renewal of your coverage. Okay, the next question is, what are the minimum insurance requirements to receive designation under the Safety Act? Here I just point out that, in the final rule at 6 CFR Part 25, in Section 25.5b, we talk about liability insurance and what are some of the things we look at. We try to make this an individualized determination for each company, because each company or each applicant, whether you're an individual or company or an entity that's a non-corporate entity, you have a different situation that you're faced with. So we encourage you to take a look at the list we have in 25.5b, things we take a look at. We try to match a liability requirement that fits your deployment situation, the risk that you face with your anti-terrorism technology, and of course your individualized financial situation. That's why Dr. Idle was saying earlier why we needed to have things such as cash flow statements, income statements, projected revenue statements. One of the precepts of Safety Act is we try very hard. In fact, we're not supposed to require you to carry insurance at such a level that it would unreasonably distort the price of your technology. So that is something that we take a look at very carefully. That's a very good question, by the way. Okay, what are the liability insurance limits required, and to whom do these apply? Again, we look under 25.5 of Part 6 CFR. Here you look under 25.5a, and there's some relevant language in there that talks about, that would be responsive to third-party claims arising from or related to acts of terrorism. Okay. Next question is, would the protections under the Safety Act apply to injuries resulting from a terrorist event overseas? That's a fact-dependent situation. The statute itself and the rules that implement it are sort of agnostic from a geographical sense, but it has to have a nexus to the United States, the people of the United States, the interests of the United States. So I think folks could see if a plane, for example, were being screened, passengers being screened on a plane coming to the United States, if we had a U.S. Embassy overseas that was protected by Safety Act technologies, things like that, you could see where there might be a fairly close connection to the United States. I will note in the final rule there's some language in there that suggests that cyber incidents, can originate overseas. They don't have to originate in the United States to impact the United States. So that's another indicator for you of how fact-specific this type of inquiry would be. Before we go on for any other questions, I would sort of ask Dr. Idle at this time if she has any other observations that she'd like to put forth.
I think that covers it. I think we thank you for your attention today, and I'd like to ask Jenny on the phone line. Is there anyone queued up on the line, Jenny, to ask questions?
Thank you. We will now begin the question and answer session. If you would like to ask a question over the phone, please press star, then 1. Please unmute your phone and record your name clearly when prompted. To withdraw your request, you may press star, then 2. One moment, please, while we wait for questions.
Okay.
We have one in the chat.
Oh, okay.
The question is, do active shooter events, mass shooting events qualify for Safety Act coverage?
That's a great question.
Yeah. I'll take a step. They could. It all depends on whether the Secretary of DHS, after looking at the facts and circumstances, determines that to be an act of terrorism. We have, to date, as we mentioned earlier, over 670 approved technologies that have been deployed through the Safety Act program. However, to date, we have never had to make a determination as whether a technology has been impacted by an act of terrorism, because we haven't had a fact situation where we've had an act of terrorism impacting one of our technologies has been deployed, where we've had claims filed. So we don't have any historical precedent to give you. I would ask you to take a look at the statute. There's a general definition there. It was provided today during one of the early slides as what constitutes an act of terrorism. It would be very fact specific. We don't have any litmus tests that we can pass on to you, but certainly something that wasn't an active shooter event that factually looked like an act of terrorism could certainly qualify, but that would be something that's not our call down at the program office level. That is a call that's to be made only by the Secretary of DHS. So unfortunately, that's about the best we can give you right now. And we hope actually that we never have to make this call as to whether an act is an act of terrorism. We hope that the technologies are put out there and serve their use to deter these attacks from occurring in the first place. Thanks.
Okay. All right. Well, if there's
no questions queuing over the phone at this time.
Great. Well, if there's no other questions on the phone and there's no other questions in the chat room queue, we'll leave the chat room open for a few more minutes just to make sure everyone can download the slides and have any additional questions addressed by our staff that's in the chat room. The audio and the slides for this webinar will be available at some point in the near future at www.safetyact.gov. As always, we thank you for joining us, and we wish you a very happy 4th of July.
Thanks a lot.